I wanted to propose a new law, and that is why the attorneys at the Legislative Council should draft all ballot measures. A few weeks ago, I found myself discussing initiatives and some of the common drafting concerns expressed by those of us who review them on a regular basis. With measures placed on the ballot by the legislature, the attorneys in the Office of Legislative Counsel, or OLC for short, they draft them because OLC drafts all legislative measures, bills, constitutional amendments, and of course the three types of resolutions. Now, measures placed on the ballot by initiative are almost always drafted by private attorneys, very few of whom have received any formalized training in drafting legislative measures. So one suggestion I made to this group of lawyers was to require all ballot measures, whether proposed by the legislature, which is done today, or by the people through an initiative, are to be written by the attorneys at the Office of Legislative Counsel. Just as the Attorney General's office is required by law to write the title and summary of proposed ballot measures and charges a fee of $2,000 to the proponents of the measure for doing so, the OLC could be statutorily required to draft all ballot measures proposed by initiative backers, and the state could charge a small fee providing this service. Now, why would such a suggestion be warranted, at least in my mind? Three of the most important words to legislative drafting attorneys, clarity, consistency, and conciseness, it come into play. And readers of ballot measures often complain about the lack of clarity, sometimes including vague or ambiguous terms and statements, often a lack of consistency with existing law. Another noted concern is failure to reconcile provisions of a ballot measure with existing law, most often statutes in the same body of law. And so what does this actually lead to? Well, most often litigation, but at the very least confusion. Why didn't the measure reconcile its provisions with existing law? Why didn't the ballot measure cross-reference particular provisions of existing law? Why does the ballot measure appear inconsistent with other laws on the topic? Confusion, ambiguity, inconsistency. We want to do whatever we can to avoid these problems in our laws. Now, this doesn't mean outside counsel can't draft ballot measures. Of course they can, and they will. They can do so with a bill today, even, as well as a resolution or a constitutional amendment by the legislature. So this proposal would simply require all ballot measures in order to be placed on the statewide ballot to be in legislative council form like other legislative measures. This is the same requirement imposed on every legislative measure that's introduced or amended in the legislature. Today, outside attorneys and even non-attorneys can and do draft bills that amend, add, or repeal statutes. But then the bill authors are required to submit that proposed language to the attorneys at the Office of Legislative Counsel. And those attorneys there, many of whom have been drafting bills in their issue areas for many, many years, will ensure consistency, clarity, and concise statutory or constitutional language is being used. Perhaps the submitted language may require a few tweaks, but in other instances, it may require a substantial rewriting. Often the attorneys at OLC readily know about other state laws that may or may not come into play. They also may not be in the same code section as the proposed ballot measure. In fact, sometimes these provisions are found in entirely different California codes. And then there should be a cross-reference or some sort of notwithstanding clause at the very least. Additionally, the attorneys at OLC know and understand the principles of statutory construction and how judges in the state generally interpret California statutes. This is an added value because they are most up to date on these principles, and the attorneys there will review and perhaps rewrite where appropriate a proposed ballot measure to better protect it from legal challenge and make it easier to implement, interpret, and enforce. Many Capitol observers know the Legislative Counsel and her deputies serve as the attorneys for the legislature. There's actually an existing provision of state law found in Government Code Section 10243 that provides the Legislative Counsel may work with the proponents of an initiative measure in its preparation, but it must be requested to do so by 25 or more state voters. and there must be a reasonable probability that the measure will be submitted to the voters of the state. Unfortunately, this provision of law is rarely used. Of note, there are also two other statutes where OLC plays a role in ballot measures. Elections Code Section 9091, which affects the state voter information guide. It has one single sentence in the code. The Legislative Council shall prepare and proofread the text of all measures and the provisions which are repealed or revised. There's also Government Code Section 88005.5. It contains the exact same statement, but it applies to the ballot pamphlet itself. So OLC is responsible for proofreading the text of a ballot measure, which is obviously technical in nature. My proposal would have them do the substantive work as well. These code sections could be easily amended to require OLC to prepare or review any proposed initiative language before it's given a title and summary by the AG's office. I think this approach would benefit lawmaking and the state's democracy if done properly.